This matter is before the court on the plaintiff's motion for modification of parenting time. Ms. Podolsky.
Thank you, Your Honor. The judgment of divorce in this matter entered in June of 2018. That order granted the defendant father standard parenting time. Since the entry of the judgment, he has not been exercising his parenting time or even a fraction of his parenting time. And in 2022 alone, only exercised 14 overnights. To date, he has not seen the minor children since August 28th, 2022. And he is moved to Indiana. He did that in September of 2022, and his new residence is 2 hours and 45 minutes away from the plaintiff. He made this move without permission from the court. He has not been participating in the medical and educational decisions of the minor children. My client, however, has been keeping him regularly up to date on all of their medical needs, including a tonsillectomy had by one of the minor children back in February of 2022 that the defendant failed to attend. He has sporadic phone contact with the minor children. When he does have that phone contact, it often lasts less than 5 minutes at a time. My client has been in contact with the defendant's mother. She organizes visits for defendant's mother, organizes meals for them to have with their paternal grandmother. We are asking this court to modify the judgment of divorce and order parenting time at all times and places as the parties may agree, because essentially that is what has been happening now since the entry of the judgment. Further, the judgment of divorce does provide language that states the defendant's father can only have contact with the minor children if it is supervised by the defendant. That language needs to remain in any and all future orders due to the nature of his felony convictions. So we're asking at this time that the court modify the judgment of divorce and order that defendant's parenting time occur at all times and places at which the parties may agree, that transportation for his parenting time be provided by defendant himself, and that he is to be present for that transportation due to the language that is necessary regarding his father. And we believe it's important that he provide that transportation because he did make this decision to move without permission from the court, and again is 2 hours and 45 minutes away from the minor children.
Okay, thank you. Mr. Blunt, what's your response to the motion?
Based on what I know of Michigan's family laws, last time I checked, as long as the domicile of the children did not change, that should not have any pertaining to me. Not to mention, as it was either become homeless or removed, and I wasn't prepared to lose even further rights to my children by becoming homeless.
Okay, well, let's address the issue. I'm not concerned much with your move, but the issue is she's asking to modify parenting time that would say that all times and places to which the parties may mutually agree. Is there any problem with that?
No, and as it was, I've made numerous contact times, both by text message and by phone call to Miss Coy about meeting up halfway and even giving gas money so that way she can return back to her homestead when becoming with my parenting time.
Okay. Anything else?
I'm sorry, my apologies, Your Honor. But she has refused each and every time.
Okay. Anything else?
Yes, also based on with the medical needs and dental and everything else, there was times that she never even communicated to me on half the stuff at all until after it happened.
Okay, well, that's another issue. And again, if she doesn't do that, you have a right to petition the court to enforce that. But based upon what you said, that you don't have any objection to modifying parenting time to say all times and places to which the parties may mutually agree. So if there's no objection, the court would order that, okay?
Well, I have an object to that because that's not exactly fair.
Oh, you are objecting to that? I thought you said you had no objection to that.
I'm sorry, Your Honor. I did not mean to have that come across like that.
Okay. Well, with that in mind, what the court will do is the court will, does believe there's a sufficient basis for modification. Court will send the matter to the referee for an evidentiary hearing, and you'll get notice of that probably the end of this week, sir, and then be prepared to have that particular hearing. Okay.
All righty.
Okay.
Your Honor, if I may make a motion at this time that the referee hearing occur in person for all parties. My client is hearing impaired. She utilizes the reading of lips to assist her, and that is very difficult to do on Zoom. So we're asking that any evidentiary hearing be a requirement in person for all parties.
Okay. You understand that, sir? You'd have to come back.
Okay, if that's the case, then I require that this being during the week, Monday through Thursday, because I work Friday, Saturday, and Sunday.
Okay. Well, what we'll do is we'll try to accomplish that. If, for instance, if you get a hearing notice and the referee sets it for a Friday, then what you're gonna have to do is contact Ms. Podolsky and we'll try to move that, okay?
All righty.
So we'll set it, Ms. Podolsky, you can why don't you do that, put it in an order that there'll be a referee hearing, because we'll refer it to the referee, but if you put that it would be in person and that it would occur Monday through Thursday, then hopefully we can eliminate that conflict with Mr. Blunt's schedule as well.
Okay, thank you.
Okay, thank you all. Court will end this matter at 9:13 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Vanderhorst on behalf of the defendant, Ms. Podolsky on behalf of the intervener. In this matter, the matter is before the court on the intervener's notice for entry of consent judgment. Ms. Podolsky.
Thank you, Your Honor. We were here a few weeks ago and we placed an agreement on the record as it relates to custody, parenting time, and support of the minor child in this matter. We have noticed this up for entry today. We did not hear back from defendant regarding income. We did understand he was on Social Security disability. We used an amount that was known to us from the Social Security Administration as being in the general ballpark, if you will, of a monthly amount. It was just over $300. Unfortunately, I don't believe counsel for defendant had been able to reach him, and because of that, we have noticed this up for entry today.
Okay, Mr. Vanderhorst, what's your response?
Thank you, Your Honor. In regards to the order does appear to correct what we put on the record and what Mr. Green agreed to. My concern is just I need to confirm with him his monthly Social Security that he is receiving that was put in the Uniform Child Support Order, just to confirm that is correct.
Okay.
So,
Mr. Green, are you aware of what your monthly disability is?
I think it's 0 now, Your Honor.
Okay, well, you're going to have to provide some information to Mr. Vanderhorst, and he can provide it to Ms. Podolsky.
That's going to be difficult, Your Honor. I'm in a jail cell with no bond.
I understand, but well, if you can contact somebody to get some documentation or just provide it to Mr. Vanderhorst when you can. I understand.
Not likely.
So, Ms. Podolsky, we're just awaiting front of the court. We haven't had the approval yet, so when we do, we can get it entered at that time. And Mr. Green, when you can get the income information that provided to Ms. Podolsky, and then maybe we can resolve that issue as well.
No, I can't wait.
Okay. Okay, thank you. Court will end this matter at 9:05 a.m. You're free to go. Have a good day.
Thank you.
thank you, Your Honor.